California has 1 week left in its 2026 legislative session. 3 anti-gun bills are on the Senate floor right now, and if Governor Newsom signs all 3, which everyone expects him to do, California gun owners will wake up to a state where a red flag order can confiscate your ammunition as a separate criminal enforcement action, where every new 3D printer sold must include a government algorithm designed to detect and block firearm blueprint files, and where buying any firearm requires completing a government-mandated training course before a single transaction can proceed. 3 bills, 3 constitutional violations, 1 governor who has never met a gun control bill he would not sign. But here's what makes this video different from every other California gun law coverage you have seen this week. This is not a story about Sacramento politics. This is a story about 3 separate federal court challenges that are already being drafted by NRA, FPC, and SAF legal teams. Because every single one of these bills fails the same constitutional test the Supreme Court established in Bruen in 2022. No founding-era historical analog, no historical tradition, no constitutional authority. The question is not whether Newsom will sign these bills. He will. The question is whether any of them survive a federal judge. Let me take you through all 3, precisely, one by one, with the legal analysis every California gun owner needs before September 12th. The first bill is Assembly Bill 1753, and I need to explain what this bill actually does, because the way it has been described in most coverage is incomplete in a way that matters legally. California already has a gun violence restraining order framework, enacted in 2016. A GVRO prohibits a restrained person from purchasing or possessing firearms and ammunition and authorizes law enforcement to remove any firearms or ammunition already in the individual's possession. 3 types of GVROs exist: a temporary emergency GVRO, an ex parte GVRO, meaning issued before the restrained person is notified, and a GVRO issued after notice and a full hearing. The existing GVRO prohibition already covers both firearms and ammunition. That is already in the law. What it did not do consistently was apply the enforcement machinery, the relinquishment procedures, the verification requirements, the violation consequences, the language on the face of the restraining order itself, equally to ammunition as it does to firearms. Some provisions mentioned firearms and ammunition. Others mentioned only firearms. AB 1753 adds the word ammunition to every provision that previously referenced only firearms, ensuring the full enforcement apparatus applies to ammunition with the same force it applies to guns. The practical consequence: when a GVRO is issued, the restrained person must surrender any firearm and ammunition within 24 hours, either to law enforcement or to a licensed dealer. Under AB 1753, the failure to surrender ammunition is now as explicitly criminalized as the failure to surrender a firearm. Contempt of court charges, criminal penalties, the same enforcement machinery, applied to a box of shells. Now here is the constitutional question AB 1753 creates, and this is where the Bruen analysis becomes direct. Your channel has covered the RPO and GVRO framework in detail. The due process challenge to ex parte orders, the government taking your property before you know a petition was filed, applies to AB 1753 with equal force. But AB 1753 creates a separate Bruen question. Does a founding-era historical tradition of separately confiscating ammunition, distinct from firearms, exist? The founding era regulated the possession of arms. It issued restraining orders in some form. What it did not do is create a separate enforcement framework for powder and shot as a distinct category of confiscable property with its own surrender timeline, verification requirements, and criminal violation consequences. The government must now produce a historical analog not just for disarming dangerous persons, which Rahimi addressed in 2024, but for separately regulating the ammunition those persons possess as an independent enforcement action. That analog does not exist, and the federal challenge will be filed on exactly that ground. The second bill is Assembly Bill 2047. This one is legally unlike anything California, or any state, has passed before, and it raises constitutional questions that extend far beyond the gun law niche into First Amendment doctrine that courts have not resolved. AB 2047 requires the California Department of Justice on or before September 1, 2028, to publish written guidance on performance standards for a firearm blueprint detection algorithm, software capable of identifying digital files used to print firearms or illegal gun parts. On or before March 1, 2029, any business that produces or manufactures 3D printers for sale or transfer in California must submit to the DOJ an attestation confirming that each make and model they sell includes a compliant detection algorithm. In plain English, after March 2029, you cannot legally sell a 3D printer in California unless it contains government-mandated software designed to detect and block firearm-related print files. Let me be precise about what this bill does not do, because imprecision here creates legal confusion. AB 2047 does not ban 3D printers. It does not ban owning a 3D printer. It does not create a new crime for printing a legal firearm. It mandates that the hardware itself include surveillance technology as a condition of commercial sale in California. Your existing 3D printer is not affected. A California resident who already owns a printer without the detection algorithm faces no direct compliance obligation under this bill. The mandate targets manufacturers and sellers, not end users. But the practical effect, if every legally sold 3D printer in California after March 2029 must include this algorithm, is a de facto technological barrier to the private manufacture of legal firearms for every new printer purchaser in the state. Two constitutional questions, neither one is settled, both are significant. The First Amendment question, digital files, including firearm blueprint files, are protected speech. The Supreme Court has held that computer code is constitutionally protected expression. A government mandate requiring manufacturers to build technology that detects and blocks specific categories of digital files raises a compelled speech question and a prior restraint question that goes well beyond gun law. The NRA has noted that AB 2047's concerns are shared not just by firearm owners but by tens of thousands of STEM educators and technology professionals. That is not a coincidence. This bill is constitutionally aggressive in a way that cuts across traditional political coalitions. The Second Amendment question, on August 18, 2026, 8 days ago, Chief Judge Reed O'Connor of the Northern District of Texas struck down the ATF's ghost gun rule and wrote explicitly that self-manufacture of firearms in America was common and indeed foundational to establishing our nation. That language is the Bruen historical tradition finding for private gunsmithing. AB 2047 creates a technological barrier to exactly that historically protected activity. The state of California is mandating surveillance technology to prevent conduct that a federal judge just found has deep roots in American history and constitutional protection. The collision between O'Connor's August 18th ruling and AB 2047 is the constitutional argument that will define the federal challenge. The third bill is Senate Bill 948. Your channel covered the Colorado permit to purchase comparison. SB 948 is the California version, and it is broader than Colorado's law in a way that matters. SB 948 dramatically expands California's firearm safety certificate requirements by mandating a minimum training course including live fire exercises and state-prescribed classroom instruction before any firearm purchase. Not just semi-automatic firearms, any firearm purchase. Colorado's SB 25003 covers specified semi-automatic platforms. SB 948 reaches every FFL transaction in California. The scope is categorically wider. CCW holders are currently exempted under the amended version. The effective date is January 1, 2028, giving California more runway than Colorado's August 1, 2026 implementation. But the constitutional question is identical. Does a founding-era historical tradition of requiring government-issued certificates, mandatory in-person training, live fire exercises, and prior government approval before purchasing a firearm exist? It does not. The Bruen test requires the government to produce that tradition. No founding-era law conditioned the purchase of a firearm on completing a government-designed training curriculum and obtaining a government-issued certificate. The federal challenge to SB 948 will mirror the Del Toro vs. Polis challenge to Colorado's law, which is currently before District Judge William Martinez with an injunction motion filed August 11, 2026. The Colorado injunction ruling, expected within days to weeks, will be the most closely watched preview of how a California federal court evaluates SB 948 the moment it is challenged. The Trump DOJ's Second Amendment section has filed 7 lawsuits in 7 months against Virginia, California, Colorado, Denver, D.C., Los Angeles County, and the Virgin Islands. SB 948 is exactly the kind of permit-to-purchase scheme the DOJ's section has already litigated against in multiple jurisdictions. Whether DOJ files an 8th lawsuit targeting California's training mandate specifically is the open question. Given the pattern, it is a reasonable expectation. Now let me pull all 3 bills together, because the constitutional thread connecting them is the same thread running through every major Second Amendment case your channel has covered. AB 1753 fails Bruen because there is no founding-era tradition of separately confiscating ammunition as a distinct category of property under a civil restraining order enforcement framework. AB 2047 fails Bruen, and likely the First Amendment, because no founding-era tradition supports mandating surveillance technology to prevent private firearm manufacture, which O'Connor's August 18th ruling just confirmed is historically protected conduct. SB 948 fails Bruen because no founding-era tradition supports requiring government certificates, training courses, and prior approval before purchasing a firearm. 3 different laws, 3 different mechanisms. The same constitutional answer: the government cannot produce the historical tradition Bruen requires. Every one of these challenges will be filed in federal court. Every one of them will cite Bruen. Every one of them will lose at the district court level in the Ninth Circuit, because the Ninth Circuit has been the most hostile to Second Amendment challenges of any circuit in the country, and every one of them will eventually reach the Supreme Court, where the post-Bruen majority has now struck down 4 major gun regulations in the past 2 years. Let me close with the compliance picture, stated precisely for California gun owners right now. None of these bills has been signed. As of August 26, 2026, the California legislature is in its final week of floor votes. AB 1753, AB 2047, and SB 948 are eligible for Senate floor votes this week. The session closes September 12th. Newsom has until the end of September to sign or veto each bill. Your compliance obligations have not changed today. California gun owners operate under existing law until each bill is signed. When they are signed, the compliance timelines are these. AB 1753's ammunition enforcement provisions apply to existing GVROs immediately upon signing. If you are currently subject to a GVRO in California, consult a licensed attorney about whether the explicit ammunition provisions change your obligations. AB 2047's manufacturer attestation deadline is March 2029. No immediate obligation for individual gun owners or existing printer owners. SB 948's training requirement takes effect January 1, 2028. CCW holders are currently exempted, no immediate obligation. Watch 4 things over the next 30 days. Newsom's signature dates, the Colorado Del Toro injunction ruling which previews the SB 948 challenge, the first federal filing against SB 948 expected within 30 days of signing, and whether the DOJ Second Amendment section adds California's training mandate to its list of targets. California has 1 week, 3 bills, 3 federal court challenges being drafted, and 1 constitutional test that none of them can pass.